Thank you. And good evening, everybody. My name is Jo Swaffield, and I'm Dean of the Faculty of Social Sciences. And it's my pleasure this evening to be able to welcome our speaker, Professor Colm, who's going to speak to us on the topic of taking stock and looking forward, the past, present, and future of equality law. So I think that's the whole of it. Yes. And all within the space of 1 hour. So I'd just like to say a few words there about Colm's achievements so far, which are really quite impressive. As everybody will probably know, Colm is a professor of constitutional and human rights law at UCL and Vice Dean Research for the Faculty of Laws. Colm is a graduate of University College Cork and King's Inn, and he has published extensively in the fields of comparative constitutional, human rights and anti-discrimination law. So a highly suitable speaker for the Stefan Centre this evening. And he's also acted as a specialist legal advisor to the Joint Committee on Human Rights and the Women Equalities Committee of the UK Parliament, as well as a range of organisations such as the ILO and the European Commission. From 2006 to 16, for a decade, he was a member of the European Committee on Social Rights of the Council of Europe and was vice president of that committee from 2010 to 14. Since 2008, he has been a member of the Academic Advisory Board of Blackstone Chambers in London, and I'm sure it was a great privilege by being nominated by the Government of Ireland as a candidate for the European Court of Human Rights, and his work has been cited by the Court of Justice of the EU and Irish Supreme Court. So, Colm, over to you for the lecture this evening.
Right. Thank you very much, and thank you all for coming. I'm a little bit alarmed given the excellent fire evacuation notice who gave us that you need a University of Southampton ID to exit after 6 o'clock, which puts me in a vulnerable situation. But I'm sure we'll be looked after if it comes to that. It's a great privilege and honour to be here in Southampton, my first time, and it's a great privilege and honour to be giving the Stefan Centre annual lecture. I told Stefan in our meal just now that I have the privilege of teaching some of his epic cases to our LLM employment law class every year, GMB and Allen and a few others that some of you will be aware of. So it was a great privilege to meet him and to hear all the stress and agony that's bringing those cases involved before happy outcomes. So it's a great privilege to meet him and a great privilege for me to be giving this annual lecture. I didn't stint in ambition in putting this together. So apologies for those of you who prefer your legal lectures to be more targeted, doctrinal, precise. I am painting with a broad brush in the next 40 minutes or so. I was querying whether that was a wise choice up until last Thursday when Reform announced that they were thinking of abolishing the Equality Act, which I thought, while being, as I will argue today, unsurprisingly bad for the country, might actually be quite good for this lecture from my selfish point of view. So my big title, Taking Stock and Looking Forward, the Past, Present and Future of Equality Law. When I talk about equality law, I'm deliberately using that phrase as a term of art in a way. I'm including in my analysis legislative anti-discrimination law, equal pay law, race discrimination law, discrimination law, and so on, as codified in GB under the Equality Act 2010. But I'm also talking, and the reason why I'm using the broad phrase equality law, I'm also going to discuss in passing other elements of UK law which have a similar thematic focus, a focus on equality and non-discrimination norms, in particular those aspects of public law that are concerned with equality and anti-discrimination. Case law surrounding Article 14, right to non-discrimination protected by the ECHR, as incorporated into UK law and the Human Rights Act, relevant common law norms insofar as they have much substance at all, and various other aspects. I emphasize this because equality law, when in discussing equality law, you can no longer just focus on the legislation. It's necessary to look at some of this wider contextual background. not least because you have key cases. For example, most recently, I'll come back to it, Higgs versus Farmer School, where actually the shape of the legislation has been substantially reinterpreted in light of these wider human rights norms. So I'm talking about equality law understood in a broad sense of the concept. I'm primarily focusing on the UK, but I'm also going to mention developments in, I say Europe, I should have said the rest of Europe, keeping the UK in Europe, but Europe, the US, and the wider world in general, okay? My principal concern is with the dynamics of this area of law, in particular, its evolutionary trajectory over time. I want to explore how this particularly broadly defined area of law, equality law, has evolved over the last 50 years or so. I should say there's a couple of different research streams coming into this talk I'm giving. I've been involved for the last few years with the Arts and Humanities Research Council funded project to explore the history of sex discrimination law, going back to the late 1960s with historians and industrial relations experts. I'm also, of course, have been involved myself in legal developments in the field of equality law over the last 20 years. As is mentioned in the introduction, I was specialist legal advisor to the Joint Commission on Human Rights when the Equality Bill, what became the Equality Act, was going through Parliament 2009 to 2010. So I have my own personal engagement with that. And of course, I keep an eye on doctrine as it evolves. And so I'm trying to pull together a sort of analysis of the evolutionary trajectory of equality law as it's developed over time. So yes, painting with a broad brush, but I'm trying to sort of capture, if you want, some of the evolutionary dynamics and how this area of law has evolved and continues to evolve. I'm also impartially, I'll be engaging with doctrinal development through case law and legislation, but I'm also mapping that doctrinal development against the context of background economic, political, and social factors. Equality law, like any other aspect of law, is permeable to external factors. If you read a tribunal judgment, or if you read a court judgment, in particular when it comes down to discrimination law, it can read like a technical exercise. Okay, I often warn my students who sometimes think that, you know, if they're doing my discrimination law seminars, that this is going to be full-on philosophical musings about the role of minorities in society. And instead I'm saying, well, this case involves section 12.5 of the such and such act as creativity interpreted by the EAT in 1998 and so on, okay? So equality law can often manifest itself. Many equality law decisions are highly technical and specialist. Okay, Stefan will know this probably better than almost anyone. But of course, like any other area of the law, legal developments here are permeated and influenced by background socioeconomic context. And part of my discussion today is to show you, is to say something about how legal developments, doctrinal, legislative, case law developments over the last 50 years can, if you want, can be shown to echo and be influenced by and interact with background socioeconomic factors. And I think that's quite important for discussing our current moment, the current partial legitimacy crisis that equality law may be facing at this current moment. Okay, I use the past, present, future framing as a sort of heuristic device to provoke discussion about how equality law has grown and developed, its current challenges and its potential future. I'm going to throw in a content warning. Not all of the future-facing prognostication I engage in, which is a bit crystal balling in the final couple of minutes of my talk, it's not necessarily going to be very optimistic. Okay, for various reasons I'll explore. So I just think I just think I should warn you in advance. Past of equality law. Now I'm pulling together a range of research outputs from this AHRC research project I've been involved in and from the general literature involved in this field. If if you trace the evolution of equality law up to, as a useful cutoff point, the codification of UK equality law in the Equality Act 2010, what you saw was an extended period of 40 to 50 years where very vague and very abstract political commitments reflected in ILO conventions and other norms, which lacked little in the way of any concrete political, tangible bite, certainly no legal bite, gradually over time crystallized into enforceable legal norms. People are sometimes surprised at how far back the formal political commitments to equality goes. You look, and this may be a little bit unexpected, if you look at the Treaty of Versailles, you will see the equal pay for work of equal value principle lurking in the Treaty of Versailles 1919. Not perhaps where you would expect it, but in one of the multiple sets of, some of the clauses of the Treaty of Versailles deal with the establishment of the International Labour Organization, one of whose foundational principles was equal pay for work. So you can trace the UK's formal treaty commitment to equal pay for work of equal value to 1919 and the Treaty of Versailles. Okay, now good luck enforcing that in any court or tribunal in the UK until the early 1970s. Some of you will be aware of the judicial review case involving Poplar in the 1920s, where the Labour councillor and Poplar introduced equal pay for work of equal value and lost a judicial review action brought against it on the basis it was an abuse of public resources, engaging in such silly crusading, waste of public money, irrelevant considerations, etc., etc., etc. So, you know, for years you had a formal abstract commitment, not just in Treaty of Versailles, but in political rhetoric and, you know, government ministerial statements and UN treaties being signed and so on, to the concept of equal pay for work of equal value and similar, sorry, not necessarily equal value principles, but equal pay principles and other core non-discrimination principles. But of course, they existed as very tenuous commitments. But in the late 60s and early 70s, a variety of factors, these tenuous abstract commitments began to crystallize into enforceable legal norms. Started crystallizing Race Relations Act 65, Race Relations Act 68, Equal Pay Act 1970, Sex Discrimination Act 1975, Race Relations Act 1976, and then over time, Disability Discrimination Act 1995, keeping on going. You had a slow, incremental, halting, contested process, but gradually the architecture of equality law was built up from 1965 to 2010. Okay, driven by legislative reform with particular politicians such as Barbara Castle being very, very influential in driving forward the law. Civil society pressure being very, very important, campaigning groups and so on, and legal campaigning. This is an area where lawyers played a key role in driving forward social change. All played a role. European developments were often incredibly important. Often the European train pulled the rather slower UK judicial carriages in particular along behind us. Now, there was a bit of a give and take process here. Legislative developments in the UK influenced the evolution of the EU Equal Treatment Directive, for example. And there was a process of transnational learning. At the beginning of my career, I worked for Lord Lester of Herne who was one of the architects of the Sex Discrimination Act and the Race Relations Act. And he will say that he first was interested in equality law doing some summer interning for the civil rights movement out of Harvard Law School in the 1960s. That led to him getting involved in the area when he wrote in initially indirect discrimination into UK law in the Sex Discrimination Act 75 and Race Relations Act 76. He was borrowing directly from the emerging US case law in Griggs versus Due Power and other key cases at the time. So there was a process of transnational learning, a complicated process of different actors crystallizing together, moving together to build up what became equality law. And it sort of plateaued, if you want, with the Equality Act 2010, a codifying piece of legislation. And at the same time, I'm going to spend less time on this, but you had gradual development of a public law dimension, an expanding Human Rights Act case law, and expanding judicial engagement with judicial review. You had the development of a sort of constitutional, quasi-constitutional, I should say, dimension to all of this. And of course, the developments at EU level and ECHR level, reaching, as I said, a plateau around 2010. I wouldn't for a moment suggest this legal framework was perfect. Off the top of my head, I can list 30 articles saying very rude things about it, some of which I wrote myself. But you had, you'd gaps in scope. You had its highly individualized focus, the need for individual litigants to battle for years to the courts, a lack of a sort of preemptive collective dimension. You had a very reactive mechanism. Litigants were forced to go through epic procedural marches to get justice and so on. You often had case law that was suboptimal, all of these things. But nevertheless, you had a very substantial architecture built up by 2010. And it's worthwhile emphasizing, I've highlighted it here, this was a striking achievement. Equality law gets normalized. We all think that equality law is something that exists. Of course, you have a ban on private employers engaged in sex discrimination. Of course, you have a reasonable accommodation requirement. We tend to normalize that while forgetting how unlike other areas of law that is, how radical equality law is in its ambitions. It sets out, most law is all about, I'm generalizing here, but most law sets out to ensure compliance with established social norms. So negligence. You should drive carefully. Most people drive carefully. If you choose to go down the road at 100 miles an hour and smash into someone's car, you get done for breaching the norms. But equality law was a little bit different, because equality law was done in the sure knowledge that, for example, employers didn't make reasonable accommodation for a person. This wasn't reflecting an existing social norm. It was constructing a social norm. There are other areas of law that do that to some extent. All law reform in some way involves both recognizing existing social norms and also building upon them. But equality law really stands out, as I've argued in a recent book chapter on structural injustice. Equality law really stands out for the way in which it sort of sets to construct social norms that weren't previously in place. And it does so in really ambitious ways. So, for example, it doesn't rely on conventional notions of fault. You might do nothing in any way morally condemnable in the ordinary conventional understandings of right and wrong, and you could still lose an indirect discrimination case really, really badly. Okay, now you could, I'm simplifying here, but in the sense of, for example, the way that indirect discrimination law in particular does away with trying to identify faults, wrong thinking, conventional notions of fault, and actually focuses on results, is actually quite radical in many ways. And we tend to normalize equality law, but actually, when you compare it to many other areas of law, it's really quite exceptional. Okay, there's also the proactive imposition of obligations on employers and service providers, like reasonable accommodation, and other things like this. In many ways, it's a radically, even though it's very taken for granted, it's actually an unusually ambitious, transformative, orientated area of law. I'm not saying it's qualitatively different, but I'm just saying in terms of its ambition, it sets out to be norm constructing rather than norm reinforcing in a way that really stands out. So we had a plateau of equality law in 2010, very well developed, an elaborate constructed architecture, which is really quite a striking achievement. Okay? I should say, by the way, that I didn't quite understand myself how radical equality law was until I started going to European events in the mid-2000s. This is slightly by the by, but the EU Framework Equality Directive in 2000 and the Race Equality Directive required all EU states to not just prohibit sex discrimination law, but also to prohibit things like race discrimination and other things, which previously in states like France had primarily been handled through the criminal law prohibition of racism. And it was really interesting going to countries like Germany, okay, incredibly sophisticated legal system, very strong constitutional protection of equality against public authorities, very strong labor law. But it was really interesting going to Germany and saying things like contractual autonomy dies a death if it hits equality law. You know, that you read an equal pay clause into a contract. Indirect discrimination. You know, everyone might have signed off on something, including the unions. Collective agreement, it doesn't matter. It dies a death if it runs up against indirect discrimination, equal pay requirements or similar. And actually, this was quite radical. In fact, the German adoption of equal pay of equality law in the 2000s was actually quite difficult, precisely because it broke with many of the assumptions as to how law should be constructed and designed. Okay, I emphasize that this is often a taken for grantedness about equality. But in many ways, for all its flaws, and the flaws are often emphasized, and rightly so, it is a socially reconstitutive set of legal demands in a way that's interesting in all sorts of ways. So when I talk about this plateau of the Equality Act 2010, it is interesting to see this as a rather exceptional piece of legal architecture. Okay, going from a situation in 1960, where the only way anyone ever won a discrimination case was to have incredibly creative lawyers. There was the famous Leroy Constantine, the West Indian cricketer, turned up in what's now the Russell Square Hotel in Russell Square in London, 1940, hotel full of American GIs who didn't want a black person staying. The hotel said, terribly sorry, Mr. Constantine, you stayed here before, lots of Americans here, you can't stay, right? He was outraged, rightly so. He went, he got some good lawyers, there was no equality law at the time, 1940. He won his case because they dredged up an 18th century precedent going back to equity, saying that inns couldn't turn away customers. Okay, in one of the greatest, most creative pieces of lawyering that anyone's ever done, right? But that was the only way you used to get a remedy. Right? So up until mid-60s, there was no remedy. There was no remedy unless you had the most creative lawyers in this. But since then, we've built up this huge, creative, ambitious architecture. Okay. Now, it's interesting to think about the background socioeconomic dynamics to this development. It was really interesting being involved in this, looking back at the history of sex discrimination law, to go back to the late 60s and early 70s, to an era of collectivization, of sectoral agreements, of negotiated pay scales, of a much more collectivized labor market with strong union influence. And it's very interesting when you look at the past history of famous equal pay cases like the Dagenham case, how if you dig into the history of that the history of that reads much more like a collective labor action than we tend to read it back now as a sort of equal pay action. It was an initial dispute about job ranking, job descriptions, and so on. Okay, so it's interesting that equality law developed in this extraordinary, quite radical way, just as the sort of background socioeconomic political environment was completely transforming. Sort of the old, highly unionized, collectivized employment architecture of the labor market gave way to a much more individualized labor market. What some people describe as the dissolution of vertical contract of employment over the last 10, 20 years. And it all happened against the background of quite sweeping social change. Okay. Now, by the way, this is sometimes used as an argument in the critical literature to attack discrimination law. to sort of frame it as a child of neoliberalism. I tend to push back against those arguments. You know, the last 50 years have been interesting. I've seen a huge shift of power towards capital and away from labor. But they've also been quite transformative. You know, I like to tease some of my colleagues who sort of say about 30, 40 years have been terrible. Many labour law colleagues who Joe and I will know. And I like to point out that there's actually been this extraordinary liberationary period of 30, 40 years once you start thinking in gender terms. Once you start thinking in the large-scale liberation of women, of LGBTQI people, of persons with disabilities, and so on. So this extraordinary build-up of the architecture of discrimination law interacted with a change to our working lives and collective functioning as a society, more of an individualistic society, but also in many ways more of a for good or for bad, and there are trade-offs in all of these things, a society where sort of individual lives were freed up to some extent. A more liberalized society in the original 19th century version of the concept. And in the extended paper, I sort of trace on how this impacts certain of the development. So, for example, the more individual focus of discrimination law over the years sort of maps actually what's happening at ground level. Okay. And you can write a whole history on, in particular, the relationship between trade unions and litigants in equal pay and sex discrimination actions. So Stefan himself could write many chapters in that book. But as you may be aware, some of the collective structures were almost the most resistant element to this new expectations about race and gender and disability equality. So this development of this elaborate architecture of equality law needs to be understood against this background of social transformation. Okay. Now I could speak forever about that, but I'll move on because I've looked at the past of equality law, the construction of equality law up to 2010. We now come to our present moment. Equality law is imperfectly, as in it's not always enforced as well as you would like. There's big areas, as the Me Too scandals demonstrated, where very clear-cut situations of breach of sex harassment laws, for example, were simply not enforced in entire areas of industry. Okay, so that's why I say imperfectly embedded. But you have this phenomenon where you have this general social pattern where equality law is embedded in law, it's embedded in legal practice, lawyers know it exists, litigants know it exists, very imperfect, really limited in some ways, in all sorts of ways, but it is part and parcel of our ordinary function. So much so, I was interested in, I'll come back to this in a moment, Keir Starmer's response to the Reform's proposal to abolish the equality laws. I thought really interesting. He said it's anti-British, which is interesting for something that's less than 50 years old. Okay, but I think that shows to some extent how, for all its many imperfections, it's become embedded in our day-to-day function. Okay, and for any of you who do a senior management role, you know all about equality. Okay. And it's part and parcel of how our institutions operate. And you various dynamic areas. Law continues to develop. Religion and belief discrimination, for example, has become a massive equality ground in its own right, with a lot of case law development, which was totally unpredicted, I can tell you, when the Equality Act came in 2010. So it's an area of law that continues to generate, to have its own dynamism, to generate new and interesting precedent and so on. But it is also increasingly controversial. Now, in saying this, I'm not suggesting that there were good old days where everyone was really cool with the idea of equality law and that everyone was totally relaxed about it and we're all eager to maximize full compliance with every aspect of equality. I'm not suggesting that for a moment. But what we are seeing, this is a relatively recent phenomenon, is direct challenges direct and explicit challenges to the normative basis of much of equality. Okay? So whereas much of the sort of resistance to equality law used to take in the 80s and 90s, used to take a form of foot dragging, inadequate implementation, a sort of a failure to take it seriously, finding ways around it. But you rarely had politicians coming out and saying, this stuff just needs to go. We should be able to cheerfully discriminate against all sorts of people. You rarely had that message being explicitly set out, as opposed to maybe whispered in corners. But we've seen this change. We've seen the rise of ethno-nationalist identity politics, the accompanying backlash against the politics of recognition the last decade. We've had the consequences of economic stagnation, of employers increasingly chafing against the constraints of equality law. And we've seen post-Brexit hostility against the juridification of political choice in this context, reflected in particular in hostility towards the ECHRs. This increasing pushback against the idea that judges should be deciding all of this, or judges and lawyers against. And that's and this backlash, we've always had lots of backlashes. Susan Faludi wrote her famous book on the politics of backlash back in the early 1980s. But we're seeing this backlash coded in terms that involve sometimes an explicit challenge to the normative basis of the law, as opposed to coded challenges. Okay. So you can trace this really interesting, colleague from UCL doing this really interesting re-emergence of Powlite in a Powell-style rhetoric. Okay, a sort of a direct sort of set of statements that this country is for particular ethnic groups. Okay, this country is primarily a vehicle for advancing the interests of certain specific ethnic groups. Some people who aren't part of that ethnic grouping, they've come in and we're not going to kick them out, possibly, but this is the state project, is the advancement of these particular ethnic groups. It's Powlite rhetoric. Fascist rhetoric, perhaps, but it was something that very much but it was very much coded. But now we see this expressed in explicit terms. Okay, very explicit terms in US politics, and of course, all this reflects wider global shifts. Equality law imposes discipline, disciplines employers, it disciplines service providers, it disciplines public authorities. We all have to do stuff with equality law that involves work. We need to think about reasonable accommodation. We need to think about accommodating student needs. Okay, we need to think very carefully about redundancy. We need to think very carefully about employment policies. We're subject to an ordering discipline through equality law. But increasingly, we're seeing a pushback against this discipline. A demand by employers, a demand by politicians who argue, well, we should be able to cut loose against all of this stuff. Okay. All of which is beginning to call into question the equality law that was established. Being very graphically, I've already mentioned, issued reforms call last week for repeal of the repeal of the Equality Act. Different reform people say different things about this. Some people, like Robert Gendrick, just say, I want to get rid of the positive equality duty. Others, like Suella Braverman last week, said, I want to go back to the old and not very smart idea of intrinsic characteristics. So we protect race and sex and disability discrimination, but nothing else. Okay. So, but there's no doubt that now politicians are saying things that would have been politically quite unimaginable not too long ago. But you're also seeing, by the way, beneath the surface, shifts in doctrine, shifts in case law, again, reflecting the fact that law is never independent of what happens politically, economically, and socially. You're having shifts of doctrine. The Article 14 jurisprudence of the Supreme Court and the UK courts in general in the public law sphere is now fundamentally different than it was 6 years ago. This SC 2021 case, where Lord Reid in his judgment said in relation to the to the two-child benefit. No, it was two-child benefit. It was the household, the bedroom. No, it was two-child benefit. Sorry. He effectively said, yeah, so I know this causes disparate impact. It inevitably causes disparate, but that's just a fact of life. The real question is whether this disparate impact can be objectively justified. And Parliament has taken this decision. Parliament had a positive vote on this resolution. Therefore, it's effectively de facto immune from child. Okay? And over the last 4 or 5 years, the Article 14 jurisprudence of the court has effectively become hollowed out. So you can actually point to a series of decisions taken at the height of the Hale Court, as it's become known, in 2015, 2016, that would now be decided completely differently. Okay. So you have your big grandstanding from the likes of reform, but you're also seeing at the level of doctrine, and this isn't universal development, but in aspects of equality law, you're seeing a dilution and erosion of equality law. So that's where we are at the moment. My final slide is the future. Okay, and I'm going to keep this very short because obviously, since I'm a serious academic, anything I say about the future, I have to basically say I'm crystal ball gazing, you know. So your ability to predict the future is as good as mine. Which is to say that probably none of us are very good at it. Nothing is written, but obviously, if you look from where we are in our current moment and look towards the future, there is obviously a clear risk of the erosion of equality. The political party that are now 24% in the most recent poll and are therefore most likely to form the next UK government are going to probably, almost certainly, have a manifesto commitment to repeal of the. Okay, so it's a reasonable future prediction to say there is a risk of erosion. I'm not saying it will happen, but it's a fairly clear prediction. Stagnation is another danger. Okay, there's been a real stagnation in the development of equality law. A field that used to be dynamic in both a doctrinal sense and a legislative sense has begun to stagnate. It's not just in the UK. The standardization, the levelling up directive to accompany the Framework Equality Directive, to level up European protection in areas like disability discrimination, sexual orientation discrimination, religion and belief discrimination outside of the employment context, has been stuck in the EU Council since 2008. Every year, and I go to a conference in Brussels where we have this big talk about how equality law is developing, and every year a nice person from the European Commission stands up and says, this year we're going to get that directive through. Okay, I've heard that since 2008. Almost 18 years of my life. So we're seeing this phenomenon of stagnation. I can give other examples. And I think there is a concern here that instead of seeing a sort of regular progressive development of equality law, responding to new problems, that the field becomes stagnant. And you may have noticed that Labour's commitment coming into government to having a legislation dealing with race and disability pay inequalities has gone mysteriously silent. Okay, which is rather interesting, because I happen to know that they were engaged in fairly intensive consultation. Well, they did have a consultation document, and I know they were fairly advanced in terms of their thinking as of last autumn, but there's been a complete silence about it. Now, I think there are all sorts of issues to some of their proposals, by the way. Design of some of what they were looking at is hugely problematic, which might be the problem. But it is interesting that sort of Labour came in with clear commitments to do something about pay gaps in relation to race and disability, and that seems to have gone. So stagnation is obviously you've certainly problems. You increasingly see a frustration with law. I see it with my students, especially the more left progressive students who want to transform the world and are concerned with the legacy of colonialism and so on. And they see equality law as increasingly stagnant. So there's often a sort of a mismatch between their ambitions, what equality law. But of course, there's a wider legitimacy issue here. Sort of frustration on the left progressive side is matched by a growing ideological mobilization, as I've discussed, against equality law and against some of its foundations. And And the days of being able to sort of justify the development of equality law as a sort of technical exercise, we're just working through the logic of indirect discrimination. We should do something about intersectional discrimination because that suits the internal logic of the law. Those days are probably over. Now stuff has to be fought for politically. That you're not going to get clear doctrinal results. And I suspect this is a trend that will go on in the future. There's a real concern as well in relation to that about potentially equality law being weaponized in the other direction. So the Trump administration is now very actively suing universities for positive action hiring decisions. Those of you who've been involved in positive action decisions, I hope you're all paying attention to the relevant provisions of the Equality Act, because they've triggered freedom of information requests in the US, and they're looking at 20 years worth of academic employment decisions in Harvard Law School and elsewhere. Okay, many of which I suspect will not pass legal muster. So you're going to see equality law again being used in ways that very much vary from how it's been used over 50 years. All of that coming to an end suggests that we're in turbulent times now. Those turbulent times, I think, aren't going to go away. I think it's very unlikely that there will be a political cathartic moment where everyone goes, oh, actually, no, we don't like all this anti-woke push. And actually, we quite like the way things were. Let's go back to 2020. And so I don't think that's going to happen. I think the genie is out of the bottle now. We're at active legitimacy challenges, active political debate. So the future of equality law, I think, is going to be contested, is going to involve judicial caution, is going to involve a degree of stagnation. And it may be that equality law ceases having a sort of wide transformative ambitions to reshape society and becomes a much more technical regulatory area. Some of the wider ambitions vested in equality law will simply not materialize. That will become quite a technical exercise as you complied with the requirements, and that will be the focus. But we'll have to see what happens. Past socioeconomic issues may generate new dynamism. We'll have to see what happens there. But it's very interesting in the past, present, and future. It's interesting how turbulent the landscape is now, looking towards the future, than it did even 5-6 years ago, and how so much of the gradual accumulation of our equality architecture over the years is now contested in a very, very, very fundamental way. Okay, so interesting times to repeat the famous Chinese mixed expression. Fantastic. Thank you very much for listening. And again, broad.
Now it's time for questions. At least 15 minutes. So yeah, thanks for that fantastic talk. I think I'll not abuse my position until it's necessary. Vernie, you had your hand. If anyone, yeah, and I'll come to you after. Yeah, great. Yeah.
Well, thank you for a very interesting talkative presentation. Just one question. Your reference to the German position. I'm just wondering, in terms of that looking to the future, in terms of the position of the economy in the UK, what would be the sort of legal entrenchment or bulwark against a movement towards abolishing equality? Because in the German Constitution, in Article 3, you have equality. There's also the eternity clauses. So it's not mentioned in 79, but the association or the linkages with Article 1, human dignity, and the rule of law in Article 20 actually provides for the protection. So it's not possible to have it's a never again sort of position that we have there. Now, if we transpose that to the UK situation and the substantive or the thick part of the rule of law in terms of the Lord Stein case, the Lord Stein judgment. I was wondering, so the rule of law is also entrenched a substantive part into so the movement from dicey to the substantive part. Would that be the creative solution to responding to the potential rise of nationalism and then so maybe fascism in the current context?
Great question. Will I answer it very quickly?
Yeah, let's go.
I had a really interesting experience around 6 years ago. I was asked to contribute a chapter to an analysis of common law rights. And there were lots of judicial pronouncements over the years saying that equal treatment is a fundamental common law principle. So I said, great, I've got all these lovely judicial quotes. I had a collection, around 30 of them. I then looked at the case law. In the entire history of the common law, there's been one case where the equal treatment principle has been successfully applied to give a result for a client, as opposed to being used to decorate judgments on other grounds. And that actually made me quite skeptical of the possibility that you could start appealing to common law or rule of law values in the UK context. There's often an assumption that there's a lot of sort of rights-based norms embedded in the common law, but once you start digging for precedent, not there. And of course, you don't have the equivalent of the eternity clause. You don't have the written constitution. And, you know, parliamentary sovereignty system with the Supreme Court, every judgment it hands down now affirming parliamentary sovereignty. So there are those who disagree with me. Professor Alan Bogg, for example, thinks that the common law does contain the ingredients of constitutionalized commitment to non-discrimination. I personally am more pessimistic. You know, if reform come to power and repeal the Equality Act, then it would take quite an unusually assertive court to say, Parliament has taken the choice to get rid of all of this. I'm going to resurrect it. And I think that's a real constitutional weakness in the UK as opposed to Germany, but that's maybe a story for another day.
I was going to ask a very similar question to that, Vernon, contrasting the day-to-day embeddedness you described with the lack of actual constitutional embeddedness. We used to have EU law acting as a proxy for that constitutional embeddedness, and now obviously we don't.
Yep.
So interesting to hear your pessimism on the common law there.
I am accused of being too pessimistic on that. I must say, last 5 years haven't convinced me outright. Yeah.
And the current Supreme Court.
See the emergence, the growth of automated decision making, algorithmic decision making becoming commonplace, say for example in the insurance underwriting. How do you think equality is going to advance to handle the situation of it wasn't a human that made this decision? There's no human face to blame discrimination. There's no discriminatory thinking accessibility. How do you think?
That's a fantastic question. I sent the PowerPoint to Joe a couple of hours ago, and as soon as I sent it, I said, blast, I forgot to put in my bullet point on AI. And then I said, I'm talking for too long anyway. So the extent to which AI, and not just AI, but general algorithmic decision-making systems have been rolled out, and the very clear lack of a sustained engagement with equality law norms is really striking. There's been a mountain of academic literature produced over the last 5 years critiquing it. It's really disturbing, even though the academic, you go to every academic conference now and someone's presenting a paper on AI and discrimination. It's really disturbing how much stuff has been rolled out, with no attention being paid to that. I don't know if you're aware of the Dutch welfare scandal 2016, 2017. The Dutch introduced an algorithm to capture welfare cheats. Okay, do I need to tell you what happened? It was, it amazingly found an awful lot of North African families who the algorithm zoned into, said these are all welfare cheats. They all got prosecuted. They weren't welfare cheats at all. It was the Dutch equivalent to the post office system. Absolute discriminatory decision making built into the architecture of the algorithm. So it's a real problem.
Just have the example a data use and access bill, which is weakened our protection against any and yet you have the EU AI Act, and it's strengthening it in some cases. future, is it better for us to tackle that that inevitable discrimination that algorithms are going to come up through managing technology, or do you think we should specifically focus on?
I'm very dependent on this area and my colleagues, Michael Veal and others in UCL, who are deep into the tech. My sense as an equality human rights specialist is that there's a lot of stuff going on which you could probably litigate over time as a breach of anti-discrimination or human rights norms. But that's not enough. That the existence of these relatively abstract, high-level legislative and human rights norms to deal with the problem of algorithmic discrimination, you need to get deep into the technological architecture. Things are being rolled out too quickly. Things are happening too much too quickly for all this stuff to come right into the rescue. People need to be in there in the system design, worrying about this stuff. And so I think it's a combination of both, to be honest. You absolutely need the tech. You need the tech people to be, the tech experts to be engaged in grappling with this.
Yeah, just jump in. We'll be having a workshop in April on that specific one.
Thanks for the great lecture. I wanted to ask about your views on the coming into force of Section 1 of the Equality Act, the socio-economic unity. I don't understand your views on any, what this means immediately for positive equality limited in the UK, and B, it indicates socio-politically that can be leveraged by progressive movements.
That's a fantastic question. The biggest, when I talk about gaps in the past of equality law, and the way in which our background socioeconomic developments influence the structure of the law. The biggest single gap the equality law has, it says nothing about class or socioeconomic discrimination. It's not a protected ground, it's not a protected characteristic. Anti-discrimination law barely engages with those issues. You can sometimes get to it through indirect sex discrimination, indirect race discrimination, disability discrimination, but you have to go around the houses to get to it. There's a lot of discussion in the academic literature about changing this. Interestingly, some jurisdictions have had this in place. New South Wales, for example, since the 1970s, has generated very few cases. So I think there's a sort of interesting question about how you make this work. But anyway, Section 1 of the Equality Act, as the questioner knows very well, introduced by the Gordon Brown administration as the bill was going through Parliament, provides for all public authorities in constructing their policy architecture to take account of socioeconomic inequalities. It's giving the positive race duty a socioeconomic spin. It was never put into force. Okay, it has been in GB in general, in Scotland and Wales, it's now been, and various local authorities have voluntarily started implementing the policies in the decision making. Labour are going to bring it into effect. It is moving forward. Okay, that's a positive development. Section 1 was deliberately designed to be less effective than the positive race duty. I won't bore you with the detail, but it's much more higher level decision making than the positive race equality duty bites. But that's why in my final slide, I did sort of flag up that if you want to be optimistic, there are interesting things that can happen in the class session. There is this discussion about using the tools of discrimination law in the class socioeconomic space. And interestingly enough, in our new, very problematic politics, developments in this area are much less vulnerable to some of the current political rhetoric. If you're worried about the left behind areas, then this stuff in Section 1 of the Equality Act is potentially quite important. It's difficult to say, you're being too nice to poor socioeconomic groups, you're being too woke if there's an awful lot of campaigning about, groups that have been left behind. So it'll be interesting to see what happens here. Okay, and I can tell you there's quite a lot of policy interest across the political spectrum in some of these tools. So we could see something where a lot of other elements of discrimination law get diluted, get subject to intense pressure, whereas we actually see development in this area. Okay, in the same way, by the way, the political centre right tend to be very keen on religion and belief discrimination being ramped up. So we may see the development of equality law expanding even as a contract, okay, which will be an interesting development. We'll have to see.
I think there's an assumption that's made that section 1 is designed to protect poor communities. How does that fit with the universality principle of these provisions? Noting, for example, the announcement this week that there were going to be protected percentages of students being admitted based on their socio-economic basis, which may of course be a breach of section 1.
That's a really good question. The wording of section 1, the Equality Act, this is the socio-economic duty, is quite messy. It's messy in several different ways. And part of the messiness is that it says you sort of have to take into account impact on socio-economic equality. But that gets quite complicated for precisely the reasons you say. If you choose to set aside 25% of your law school intake for socioeconomic groupings, then you're discriminating against people who aren't in those socioeconomic groupings. And the law, but at the moment you can do that quite cheerfully because there isn't a prohibition on it. The existing state of the law actually frees you up to do all sorts of exciting positive action if you want to. But the more you regulate, the more you need to think about how law may play out in this. Equality law can sometimes be a double-edged sword. I think that I think is a very, very good example. I'm increasingly. Someone said to me recently at a conference, Colm, you are the most depressing speaker. To quote, when you were younger, you were really inspirational. That's devastating me. And one of the reasons that is out to me was that I was at this panel at Utrecht, and everyone else in the panel was so enthusiastic about law coming to the equality law coming to the rescue in socioeconomic class. And socioeconomic grounds. There was me at the end of the table, the middle-aged white man, London going. So we'll have to see. There is great potential there, but it's quite a knotty set of issues.
Well, on that note, I think we're out of time. I'm sure there'll be time for discussion, maybe milling around afterwards, or the lights are turned off, so perhaps not worry about that. So I think all that's left is to thank Colm again for a very inspiring and not depressing talk, and to thank you all for